Welcome to Legal Aspects of Adult Protective Services, Update 2018. I'm Trish Geary. Today we're going to review legal issues concerning the provision of Adult Protective Services, or APS. We'll begin by discussing federal and state statutory changes and recent relevant case law. Then we'll welcome Alan Lawitz, and he'll share some agency updates with us. We would also very much like to hear from you, so please send your questions to our panel. You can reach us by phone. That number is area code 518-474-3171, or you can fax your questions using the Questions I Have form on page 118 of your handouts to area code 518-442-6650. And you can also email your questions to us at webcast_questions@albany.edu. And just a quick word on receiving continuing legal education, or CLE credits. An application for CLE credit is pending, so participating attorneys may be eligible for 2 CLE credit hours for attending today's training. Now, if you are interested in getting CLE credit, you must sign in and out on the rosters provided using your full name, and this should be the same name you're using on the CLE credit request. You must also stay for the duration of the training, including the question and answer segment, and complete the training evaluation and CLE request form before you leave. Please be sure to fill out the CLE credit request box on this form, as it is the only way to verify your attendance. And you can find that form on page 117 of your handouts. Now, if you don't complete this section, you will not receive CLE credit. And I would like to make one last note before we begin. You can find all of the program graphics starting on page 5 of your handouts. So let's get started with our agenda today. First, we'll review new federal and state statutory changes to the Elder Abuse Prevention and Prosecution Act, the Family Healthcare Decisions Act, and Social Services Section 461M, Death and Felony Crime Reporting. We'll also discuss recent statutory changes to Article 81, Peter Falk's Law, and the CARE Act, proposed statutory changes to Article 17A and Power of Attorney, and recent relevant case law. And we'll round out our time by highlighting some agency issues, including the new Financial Industry Regulatory Authority, or FINRA, Rule 2165, convenience accounts versus joint accounts for clients, the Gatekeepers Toolkit, which is a new resource for complying with federal regulatory requirements for community outreach, available APS law-related trainings, and the 2018 hospital billing codes for unspecified adult maltreatment and adult sexual abuse. So let's begin with federal and state statutory changes, and for that, we welcome someone new to this annual training, Morgan Thurston. Morgan is an assistant welfare attorney for the Onondaga County Department of Law. Morgan is also co-chair of the Syracuse Area Domestic and Sexual Violence Coalition's Elder Abuse Committee. He has extensive experience conducting legal trainings on adult protective services issues for audiences including service providers, law enforcement, judges, and court staff. Welcome, Morgan. Thank you very much for being with us. Can you begin today by just discussing some of the new statutory changes and the impact they're going to have on APS work?
Sure. Well, thank you very much for having me. And after years of watching this program and seeing Debbie Sachs for years, I know I have large shoes to fill, but I really do appreciate the opportunity to come in and speak about this. One note I will say about if any calls come in from Syracuse, just ignore them because they're just pranking me.
Gotcha.
But we'll start with statutory changes. There is one federal one I want to discuss. It is the Elder Abuse Prevention and Prosecution Act. A few important things for adult protective. One of the most important things I want to point out is it's really, again, showing a broadening knowledge of the fact that elder abuse is occurring in our communities and across the board of all backgrounds. Mm-hmm. But some of the particulars of what the Elder Abuse Prosecution Act are going to have in it, improved data collections, enhanced victim assistance. The Robert Matava Elder Abuse Prosecution Act of 2017, that is, in a little background on Mr. Matava, he was a World War II very decorated veteran, and his son actually ended up stealing
Oh, wow.
From him, and that was the background behind this Financial Exploitation Act. A lot of that has to do with scams and enhancing criminal penalties for financial exploitation. Other things that more may directly affect adult protective is they want to come up with model power of attorney legislation and best practices for guardianship proceedings. And also possibly some model legislation for across the board for guardianships as well, which if we can make things uniform across state lines, that would be helpful. One thing on the elder, as far as what they acknowledged as well, is that for elder exploitation and prevention, they came up with a figure of not less than $2.9 billion per year. Mm-hmm. That's an older study by MetLife. More recently, the New York State Cost of Financial Exploitation study. What we've come up with, and give a lot of credit to Al and the state for doing this, the most comprehensive study of elder exploitation and financial abuse, $1.5 billion per year for New York State alone. So if you're looking at just our state, and then they're saying at least $2.9 billion for the country, it probably is a great underestimate of what's happening. But again, the important findings in the act are just that they're acknowledging how prevalent elder abuse has become. That's the federal act. The next one we'll talk about is Family Health Care Decisions Act. And Family Health Care Decisions Acts become very important in guardianship proceedings because it has to deal with when we're making end-of-life decisions under guardianships. That's the most prevalent area that adult protective will see it. And a big change that they've made to the statute for this year, effective May 28th of 2018, is the addition of attending nurse practitioners. What we know is that a lot of what you do in the Family Health Care Decisions Act to make end-of-life decisions, you need 2 doctors. What is changing now is that you can have a doctor and attending nurse practitioner. So it's a broadening and a realization of what's actually happening in the community where we're having a lot more nurse practitioners providing care. Sure. So that's an expansion which we think could be helpful. For the next slide, if you look from the AATI of 2017, one of our plenary session was Dr. Teal, and he talked a lot about telehealth and delivery remote medicine. And this change in the statute is the originating site. What can happen with an originating site is now a family type home can be deemed originating site for provision of telehealth. So you could actually have someone having a medical exam while they're actually in the family type home as opposed to having to go out to a provider, which for a lot of our clients that can be a bar to them actually getting care.
Another good change. Yes,
another important change that can be assist our clients. The next one we have up is Social Services Law 461M, is death and felony crime reporting. And one addition that they've made to this statute is they've added requirements for enriched housing programs. It's not typically when an adult protective client goes into an assisted living or a more modeled program, adult protective doesn't have the primary duty to investigate. Sometimes when we are the guardian, we're going to maintain the duty to oversee what's happening with our clients. And if any of our clients are in a setting or in a facility where they're injured, or if they pass away due to a crime, this is the statute that deals with reporting of felonies and also and death as well. So what we need to be aware of there is we're adding enriched housing programs. So you might have a guardian, someone that needs a guardian, but is not quite to a nursing home or assisted living too. So those are new statutes that I wanted to talk about for this year and coming out. What I think, so there weren't any that I felt were overly critical to day-to-day operations for us. I do like that we are adding in on the nurse practitioners for the Family Health Care Decisions Act. what I have next are some refreshers, and one of these is on the Family Health Care Decisions Act. And when I was saying refreshers, I was thinking something more recent, but this change was from 2010.
Okay.
So it's 8 years out, but what happened is I haven't been seeing this in guardianship orders. So in order for the Family Health Care Decisions Act to kick in and for you to be able to make end-of-life decisions, the guardian, you have to be given this authority. And they actually amended the mental hygiene law for guardianships and added this clause that says the power that you can put in there that we are going to be subject to, and we can refer to the Family Health Care Decisions Act. And I'm not seeing that power come through, especially when in our county, about half the guardianships that are brought by facilities, mostly hospitals. And this has not made it onto their radar. As you can imagine, with a lot of healthcare providers, their primary reasons for wanting us to become guardian is so that they can get a placement for them, or someone can secure payment of their bill. But when we take over that role, if we don't have authority to make End-of-Life Decisions Act under the Family Health Care Decisions Act, we're probably going to have that client as a full code, which is probably not what our own personal wishes are, but without having the authority to do otherwise, we're going to either have to go back to court, or else we'll have to leave them getting treatment they may not have wanted themselves. Next couple slides we have is on the Peter Falk's law, and this one is more recent. It's from 2016. And what this one, it also is around the guardianship proceedings. And most of what we'll talk about today in my case law too are around guardianships. But this Peter Falk's law, what we really need to be mindful of here is when we have family members that are fighting, and someone may be trying to prevent access to that loved one. And for this perspective, it spells out that in the guardianship order, you can say who is going to be notified of the intended disposition of the remains. That's this slide, and it can also identify persons entitled to notice when they're being transferred to a medical facility. So the guardianship order and one other one, it also has to do with visitation too. So if you want to limit who's going to be
able to access the person,
it's going to, yes, it can identify who can come in and have access and visit with the incapacitated person. If they want to, you can't make someone go in and visit, but we have had situations where one family member may be trying to prevent another family member from coming in. And this law is giving the court the authority to spell this out. Why is it important to us is because typically if we're involved and we're the guardian, we'd have a legal right to gain access and see our clients. But it's for the person that's important. If you have a fighting family, having one have the ability and the power to keep someone else from the other loved one from having access can be detrimental. And we just should be mindful that this part of Peter Falk's law should be being put into the orders as they're drafted. It's just an oversight. I think it's just outside of people's radar, but especially if there's any time there's infighting in the family, it should be included in the statute.
Make sure you've got that in there.
Make sure it's there. Another statute that's about 2 years old, the CARE Act. They're nice acronym, Caregiver Advise, Record, and Enable Act. This is going on 2 years now, and I personally have yet to really see it used or involved in, which is kind of a shame. And I think part of the burden is on Adult Protective is that when we're involved with a client and they're in a hospital setting, we should be reaching out to the facilities and seeing if they're enacting the CARE Act. Okay. And what the CARE Act allows is it allows the person as they come into a facility to identify caregivers that they want to be notified about their discharge plan. And this caregiver is also entitled to be given instruction about their post-care discharge, which I was doing a training just last week, and part of it we talk about, when you're in a hospital, you're not always thinking as clearly as you should. And what is your number one motivation?
Going home.
Is going home. And they may say whatever they're going to say whatever they need to say to get out of the hospital, which may create problems for themselves because they may not even know what their post-discharge plan is. And if they have durable medical equipment that's brand new to them, or if they have medicines or injections that they're supposed to be managing on their own, it's a great statute to be able to give people the authority to assist. Again, I'm bringing it up because I'm not seeing it in action yet. It's been on the books for 2 years, so hopefully our role as adult protective, when we're dealing with people that are in a facility or in a setting, we should be bringing this issue up and trying to designate someone that can assist them before they're discharged.
Again, going to help down the road when that person is now back home.
Exactly. On their own. And also, one of our biggest issues that adult protective deals with are potentially unsafe discharges. And with someone that's designated as a caregiver, they can intervene too and be at the table for a discharge plan and maybe object to something not being safe. Because the person themselves, again, their motivation may be, I just want to go home, or they may have some limitations in their capacity. And if they're the only person sitting at the table developing the discharge plan, it may not be safe. Next, before we get one last thing on statutes before we turn to cases, statutory proposals.
Okay.
Neither one of these were both proposed last year, and neither one passed, but they're back again, and I anticipate that at some point in time we're going to see some action on them. 17A guardianships, I didn't put any cases in here, but every year we could have 5 or 6. And over the last 3 or 4 years, I know Debbie's been presenting on 17A guardianship cases. These are guardianship cases for developmentally disabled people. And there is a different proceeding for 17A guardianships and Article 81 guardianships. The level of proof is less. And the ability for family members to actually come into court and bring the proceeding on their own without the expense of going through an 81 proceeding is much less, and it's designed for families to be able to do that. However, what has happened is in the courts, there's been a strong showing that Article 17A is falling out of favor because it's an all or nothing proposition. So if you're granted a guardianship, you can do everything for this person, and the person essentially has no rights.
No rights whatsoever, yeah.
And the underlying concept was, if someone was developmentally disabled, they never essentially developed their civil rights. So they're not taking those rights away that you're doing in an Article 81 guardianship. It's just that they never had them. What the courts are seeing, though, is that people actually have greater capabilities than what's being shown in the court proceedings, is that there's some very high functioning people that may technically meet what the criteria for a 17A guardianship, but it wouldn't be fair. And the courts are seeing this, and the courts are denying Article 17A guardianships. So what the proposal in legislation is to make it really mirror the Article 81 guardianships, so that it would be the least restrictive intervention or make supported decision making to support what this person may do well on their own, let them do that, and provide them the supports that they don't. Be a less restrictive intervention. So that hopefully, I think we're going to see something happen there. It hasn't yet. Power of attorney statute. We had major changes in 2009 and 2010, and after, what attorneys have found is that the documents have gotten very long. Because not only you're dealing with the power of attorney, you're also dealing with something called a statutory gift writer. If you want to make gifts of over $500 per year, you have to sign a separate document. And the signing of powers of attorney have become quite cumbersome. And they're complicated. And the pushback is really coming from attorneys to say, because this is so complicated and cumbersome, people aren't signing them. So taking away some of the benefit of the power of attorney. What my fear is that some of the major changes to the power of attorney is that it's building in protections. So it's not as easy for people to improperly use powers of attorney, and which has been a good thing. And we've made some headways in training law enforcement and having law enforcement prosecute misuse of powers of attorney. Now, if they simplify it, hopefully that will keep the protections in there. So I think that's all the statutory things that I want to discuss, and we'll move on to recent relevant case law.
There have been a few.
I have quite a few.
You have quite a few here. It's just going to be interesting to see, because I know you're the guy that actually works with these kind of cases day to day, Morgan, so I'm anxious to see what you have to say about these. Yeah, and
most of these are going to be concerning guardianships. And yes, that's my role in our county, is to handle the guardianships. The county is a guardian of last resort, so as these cases come in, that's why it's very important for me to stay on top of these and see what's coming our way. The first three cases I have involve guardianships and attorney's fees. This first case, Bonnie H., is interesting. We had, what's interesting on this case is that Bonnie had signed powers of attorney and healthcare proxies previously, and they were in favor of a daughter that lived across the country in California. And Bonnie was still managing her affairs on her own. And she had an estranged daughter who thought that maybe it was time for a guardianship for mom. And the court ruled against the daughter and said she didn't make any showing of clear and convincing evidence that mom lacked capacity. So, and they also relied on the fact that she had also already signed a power of attorney and a healthcare proxy, and she had a support system helping her in the community. So the court denied the application for guardianship, and what they required was that the daughter, as it was denied, was that she had to pay for the attorney's fees, which the statute does provide. And what they talked about was the purpose of shifting the fees back on the petitioner if they don't win is to caution those who would bring a frivolous petition or one who might be motivated by avarice. And so the daughter was being greedy, is what they essentially said in this particular case, and said, no, we are going to put the fees back on you. One thing that the alleged incapacitated person did, she hired her own attorney. And what the court said here was that because it wasn't an appointed attorney for her, she hired her privately hired her own attorney. She had to pay for that herself, though. So she did lose some money in bringing this proceeding, but she didn't have to pay for the petitioner's attorney. The next case is one of these cases that you put in because it's just maybe a little too hard to believe. Wow. So it's just a fact pattern that when you read it, I find it hard to believe that it happened. That on the day that this alleged incapacitated person, her husband passed away, her grandson came to her home with an attorney and had her sign a power of attorney, a will, healthcare proxy, living will, and naming the grandson as the beneficiary and the fiduciary. Pretty
durable documents there.
Yeah. So on the day of her husband's death. And the attorney also had the AIP sign a retainer letter stating that the attorney would serve as attorney for all estate matters from that day forward. So it's just that on its own just seems ridiculous. And then you couple that with the fact that the grandson had already gotten out of jail for well, it ended up being stealing because he'd taken out mortgages on his grandparents' homes and taken the money.
On their home.
So he'd already done jail time for this.
Yeah.
And so a prior power of attorney that had no relations to this actually brought the guardianship proceeding on behalf of the AIP. And it was successful. An independent guardian was appointed. The powers of attorney and other documents signed in favor of the grandson and by this attorney were revoked. The really interesting part was the attorney thereafter that drafted these, he put in an order he wanted to have his fees paid.
He's pushing it.
I actually did a little research to see if this attorney is still practicing. It looks like it. There was no grievances or anything filed. I thought it was extraordinary. But that attorney, not only he filed with it when the guardian wouldn't pay his fee, he filed a motion, and after that appealed the decision and lost. So
he did ultimately get denied, right?
He did get denied. The appeal was denied with a finding that the legal services were for the benefit of the grandson, not for the benefit of the alleged incapacitated person. So it's one of those you just can't make up fact patterns. The next case, matter of Farrell JB, is a brand new case decision that just came out of the 4th Department and was an Onondaga County case. So it was one of our cases. We weren't a petitioner, but we were a notice party because the person was in a facility. So by law, if the person's in a facility, Adult Protective Social Services has to be a notice party. What happened in this particular case, there was a granting of a guardianship, and the court ordered that the petitioner, which was Upstate Hospital, State Hospital, to pay the legal fees of both the attorney and the court evaluator. The appellate division just recently reversed that and said the statute is essentially silent on the source of funds of payment when the AIP is indigent. But what the appellate division came up with said, in accordance with the proceedings of County Law Article 18B, there should be a way to pay the attorney for the court-appointed attorney. 18B is really where the assigned counsel money comes from.
Okay.
So essentially, the appellate division is saying you'd pay the person through assigned counsel.
For an indigent, incapacitated person.
Correct. And in our county, the assigned counsel program, their contract does not cover guardianships. So this is brand new. I don't know where this is going to go as far as whether there's going to be some directive back onto the county. But for this particular case, the court's saying they should be entitled to be paid, and it should come through assigned counsel, or 18B of the county law. One thing that the court did say, however, was that there was no provision for the payment of the court evaluator through the 18B program. So that was not put into the decision. They said that the judge didn't have the authority to order the payment by someone of that. Only when the case is dismissed, just like in our last case where when the case is dismissed, the court has the authority to make the petitioner pay for the payment of the counsel and the court evaluator. In this particular case, they wouldn't allow that. Because the petition was actually granted. The person did need a guardian. That being said, I guess my advice to counties and social services, if we're bringing the guardianship, or if a hospital is bringing a guardianship for someone and we know the person is indigent, especially if we're bringing it, we should make a request or make it known to the court that maybe mental hygiene legal services should be appointed. And because they can act they can be the evaluator, they could be the attorney as well. They can't be both at the same time. So, but they can do it without charge. Sometimes we don't know This particular case, had they looked at it, it was known that this gentleman didn't have his own funds. He was receiving, I think, only SSI at that stage. So those are the attorney cases that I have. Next two are two cases on voiding actions by an incapacitated person. So someone that's incapacitated has entered into either a contract or someone's trying to evict them.
Okay.
What happens if the person was incapacitated at the time they undertook this action, or what happens during the eviction process if they're incapacitated? The first one deals with an eviction, and the appellate division actually set aside a stipulation in judgment of eviction on the ground that the tenant lacked capacity to enter into the stipulation, agreeing to leave. The legal standard that the court relied on was that the respondent offered more than conclusory assertions of stress and depression. They didn't just say, hey, I was stressed, I couldn't respond, or I didn't quite know what I was doing when I signed this stipulation. What the records supported were that she had a history of depression and anxiety, and she had a mold sensitivity. And her apartment had mold violations since 2010. So combination of the showing of her depression and anxiety and her being subjected to mold in her apartment affected her physical and mental capacity, and therefore the court was not going to stand by and allow this stipulation, allow her to be evicted from her home.
Sure.
So, and the New York City Marshals were involved in this case earlier on, and New York City is a little bit unique in that they have an eviction program where the city marshals actually will become involved in making a report back to Adult Protective. The next case was coupled with a guardianship, and there's a third-party action where someone was trying to enforce a financial agreement. And this particular gentleman, and the medical findings were agreed upon, was he was hit on the head by a piece of plywood that fell from a 50th floor and caused him a brain injury. And the medical proof was uncontroverted that he had this brain injury and that he was suffering from it at the time of entering into this financial agreement. And what the court found was thereafter the burden of proof on competence shifted to the advocate for the competency. So, and they failed to show that there's clear and convincing evidence that he understood what he was undertaking. Okay,
so the advocate just kind of didn't bring that, or didn't meet that burden.
They didn't meet the burden because it shifted back. When he proved what his underlying medical condition was, it shifted back to the person trying to say this financial agreement should stand. So, next case has to deal with attendance at a hearing for a guardianship. This particular person, the court went forward on a guardianship without the presence of the alleged incapacitated person. And she had already said that she wanted to, that she was going to come to court, and she notified them that she wasn't feeling well. And she hadn't waived her right to appear, and there was no showing that she couldn't contribute to the hearing. And so the court remanded the case for a hearing in her presence. So there was found to be an overarching value in a court having the opportunity to observe firsthand what the AIP's condition was. And the court's supposed to go where they are if they can't come to court. They'll go to the hospital, they'll go to a nursing home, they'll actually go to the person's home. But it's that important that if the person just decides to show up, you may be leery about going forward with a hearing without them present unless there's some showing that they can't meaningfully contribute. Next case deals with the privacy and whether a guardianship proceeding is an open court. Okay. This was out of Tompkins County, and it surrounded a murder case where a gentleman had murdered a UPS driver in a parking lot. and it was that did make the state news. And
yes.
what happened after that was there was a guardianship proceeding brought on behalf of this gentleman. He was initially found that he was not competent to, he was unfit to proceed to trial. So he was placed in a mental hygiene facility for a period of time. And during that intervening time, someone, I believe a mother, brought guardianship over him. And what came out of it is the district attorney's office notified the court that during the guardianship proceeding, they wanted to attend and be present during this guardianship proceeding. And the attorney for, and I'm not sure if it was the attorney, I assume it was the attorney for the AIP objected to the presence of the district attorney being there. And the court did find good cause to close the records of the proceeding and actually not allow members of the attorney or the district attorney into the courtroom. And they found that there was a liberty interest and a right to avoid self-incrimination in an Article 81 guardianship proceeding. And they felt that there would be a chilling impact on the evidence that was brought in this proceeding that's supposed to determine what capacities they may have.
This person has, yes.
And they also felt that this person's medical privacy might be implicated if district attorney's office was available and being able to see what's happened, what testimony came out in his guardianship proceeding. And what the final finding was, incapacity for purposes of Article 81 is not relevant to a criminal proceeding. It's a different level of capacity that you're looking at for a criminal proceeding. So they closed the court, and I just looked at an update, and this case did proceed to court, okay. And the person was found competent to stand trial. And there was a plea agreement, and I believe a finding of 25 years wow. for his actions, but it wasn't due to the guardianship. It was, he actually accepted the agreement.
But that's an interesting point about the guardianship and how applicable it is in that situation. A lot of really interesting cases, Morgan.
Yes, they keep coming.
Unfortunately.
And again, you can't make up some of these fact patterns, but that's one of the things is say bad facts make bad law. So it's interesting from our perspective is that there are certain cases that you don't want to make a precedent on because the fact pattern is out of the norm. So you may not want to proceed on a particular case if the fact pattern is really that crazy. We have a couple cases on third-party guardianships too where someone, a family member, was challenging either the appointment of a third-party guardian or the actions of that mm-hmm. third-party guardian. The Beatrice R.H. case, the second department held that an independent guardian was correctly not ordered to move the ward to her former residence or to a different nursing facility. So we had infighting between children, and they could not get along. And so the court in the initial proceeding appointed an independent guardian, and subsequently one of the sons wanted mom either sent home to her old home so he could provide care, or to a nursing home that was closer to where he lived. In the court, for all the reasons for the discord between the children, it made sense to follow what the third-party guardian wanted, which was to keep the person in the nursing home where they were stable and the care was good. So. Dorothy KF is another third-party guardianship, and in this particular case, the daughter was found to have been self-dealing under a power of attorney. So what the court did in this particular case was revoke the power of attorney and did not appoint the daughter to handle the AIP's finances or over the finances, but did allow the former agent, this daughter, to act as guardian of the person. So despite the fact that she had made improper decisions handling the property, she was there, and the court felt that she was still going to be capable of making the proper decisions for mom's care.
Because you can be a guardian of the property without being a guardian of the person, correct? And vice versa.
That's correct. And we've seen some cases where we've actually been assigned one or the other, and we don't like those cases because then we're typically, generally it's a situation like this where we're dealing with either discord between family members and they're fighting with themselves, or the person themselves may have acted questionably in handling finances, but we're going to allow them to continue on in the making decisions over the person as opposed to property. And it's just not a scenario that we like, but sometimes that's what we're given. So, in that particular case, they did mention that the court did approve, out of the AIP's funds, $16,000 for petitioner's attorney and $18,000 for the court evaluator. So you can see these things can get very expensive when they're contested between family members too. Next one is a Dutchess County case, and this one was actually brought by the Department of Social Services for a temporary guardian. And what was happening was this person had a large amount of assets, and the person that was taking care of her was a son of her friend, and had moved into her with her, and had also become power of attorney and healthcare proxy. And what the court did in this particular case was actually did revoke the power of attorney and the healthcare proxy. And there were actually claims of not only financial exploitation, but physical and emotional abuse as well going on in the household. So they revoked everything. They appointed a guardian. But what they also did in the guardianship, which I've never seen before, was the court found that they approved an order of protection under the guardianship proceeding. And what this court reasoned was that the order of protection was analogous to an injunction.
Okay.
They said really an injunction and a order of protection equal each other, so we can put this into effect. It's interesting and it's novel, and I like that they did that they went over and above to try and protect the needs of the person.
Yeah.
And I've never seen it, but if I have a case like this, I think we will make that request that we want an order of protection. Not to say that we couldn't go through the other means of family court order of protection on behalf of our client, which we, as Adult Protective, we have the authority to seek an order of protection and assist our clients with it, or through the criminal channels if we think that. But as we know, some of these are going to be difficult to prove. Depending, she is incapacitated, and depending on what her ability is to testify, that could make it more difficult to gain the order of protection or even a criminal setting. So having a court that's willing to think outside of the box a little bit and move forward, I think it was beneficial to the client. It isn't an appellate division case, it's a Supreme Court case, so, but I won't hesitate to cite to it if it's something that I think can assist one of our clients we're trying to assist.
Oh, it's a good suggestion, thank you. Like you say, it hasn't been appealed yet, but it's a good idea if you need to try it.
Yes, and hopefully it won't be appealed, I mean, because it did rule in favor of the county. It's just, it's just when we're looking at them as far as whether it's an appellate division case or just a Supreme Court case for its authoritative value for the next court that's looking at, maybe they'll interpret the statute different, say we don't have the authority to bring or to grant an order of protection under the mental hygiene law. So when we're proving a guardianship, the next case deals with consent. So you can prove a guardianship by clear and convincing evidence that the person lacks capacity and that they're at risk of harm, or the person can actually consent to a guardian. There's some risk when someone consents to a guardianship, because if they withdraw that consent, or down the road they withdraw the consent, or maybe what they consented to, maybe you need additional powers, so you might be in a position that you have to go back to court. This case, Deborah P., was a case where we had consent. Okay. There was a limited guardianship, and the purpose of the guardianship was for the appointment of her sister as guardian of her property just to create a supplemental needs trust. So once the supplemental needs trust was created, she had accomplished what needed to be done. 8 years later, the alleged incapacitated person filed a petition to terminate the guardian as she was fully capable of managing her own finances. And she felt her sister was overextended and couldn't handle the duties anymore. And Adult Protective and the court evaluator, neither one of them or social services did not object to the removal of the guardianship. Okay. And the Second Department held that the sister, she failed to meet her burden to show that she lacked clear and convincing evidence that she lacked capacity. She didn't feel that she was going to be safe, but she had to prove it. The burden was on her thereafter that, yeah. Because she did it on consent. So there's some risk if you're going to take a case on, it may be easier initially to say, let's not have a hearing, the person's consenting. I think spending the shorter time of putting a witness on the stand and proving that the person lacks capacity can avoid situations like that. Not that this case proved anything that was wrong, because maybe she had capacity, but it's just to be mindful that on consent cases, there's some risks there. Next case deals with end-of-life decisions, and this case is worth reading. It's 20 pages long. It dealt with a young person. She was 37 years old and had complications of a pregnancy. And she went into cardiac arrest and was thereafter in a persistent vegetative state and on life support. Her husband was her appointed guardian, but he did not want to make an end-of-life decision. Okay. So what he did was he allowed a special guardian to be appointed for that purpose of handling end-of-life decisions. And what they really did is they went through and evaluated the Family Health Care Decisions Act and whether the husband had, well, actually the special guardian had met the terms that were in the Family Health Care Decisions Act. And I will say that the proceeding to challenge the ability to withdraw life support was brought by this individual's parents and a cousin. Okay. So they were the people that they wanted life support to continue. Mm-hmm. Ultimately, the court ruled in favor of the special guardian and found that end-of-life decisions, or that life support could be removed, because there was a showing through the medical testimony that continued respirator would be excessively burdensome on the client and the treating. And that was supported by a treating doctor and a neurologist, mm-hmm. which would satisfy the requirements of the Family Health Care Decisions Act. And so interesting from the standpoint that we had a spouse who was actually a guardian, and the spouse actually occupied the first two spots of the Family Health Care Decisions Act, guardian and a spouse, but he didn't want to make the decision. I get it, he wanted someone else to make that decision for him, and there was no proof of what her wishes were. And the family members also were not able to provide medical evidence that she was going to regain any capacity, any chance of regaining capacity. So it's, again, 20 pages, but it's worth looking at.
Long reads are sometimes full of valuable information when you're looking for important details. What
I liked about that case, because it went into detail on how the Family Health Care Decisions Act should be applied, and that was worthwhile. Next case, Johnson, was someone challenging, it was actually a probate case, but it was someone challenging the actions of a power of attorney. And what they found was this person had violated It was a will contest between the person's children, and pursuant to a power of attorney, the person that was appointed as her agent had taken $63,000 in cash out. There was another $220,000 in cash there, but what the court found was that she had violated the power of attorney, or actually the actions of power of attorney would be deemed void because what she had done was contrary to the person's will. At that time. Okay. She signed a will after that that essentially was going to give was going to give the money to this power of attorney, to this agent. But at the time that the money was taken under the power of attorney, the will had said it was supposed to be split amongst the children. So the court said, no, you violated the terms of her testamentary plan. We're going to set aside those distributions to you. A very similar case. This one didn't actually, similar in the fact that it was a power of attorney and it was an estate case after the person had passed away. But in this particular case, the people failed to show that the power of attorney had acted improperly at all.
So they couldn't prove any impropriety.
They weren't able to make any proof for showing that the decedent that had suffered from any physical or mental incapacity, or that she lacked the ability to manage her affairs, or anyone was imposing their will on her. She was able to exercise her own free will, so they didn't make any of those showings, so they weren't going to even look back on what the person, the decedent had. And they were also operating under false beliefs that she had around $90,000 and there was no showing. She only had like $9,000. Okay. So again, looking back on the actions of power of attorney in a state proceeding, it's not normal where we're doing it, but it is there. The next, I just want to, with powers of attorney, there's such a critical area. We have 2 ongoing cases right now with challenging, we've brought special proceedings challenging a particular power of attorney, agent under a power of attorney. And this person has acted, we've had 5 referrals on different power of attorney cases. The other cases have either been resolved or someone passed away, but what we've done is we've brought special proceedings against this power of attorney to not only produce, in one of the cases, produce a copy of the power of attorney, which they have not done, and to also provide us with an accounting. So under General Obligations Law 5-1505, they have to provide, after we give them written notice, they have to provide within 15 days an accounting. They didn't provide us with anything. So we brought a special proceeding and required them to produce it. Gentleman did not show up at court, called the court on the morning of court and said he had the flu. Court did not accept that argument and entered
default.
Just said an order demanding that they gave them a deadline to produce an accounting and a copy of the power of attorney for the one. They did not produce anything. So where I am at in that case, both those cases now, is now I have to file a contempt motion. So it's burdensome from us that we're having to go through these steps, but ultimately we'll get there. But it's a change in the power of attorney law that, again, when we were talking about it before, we want to see these protections stay. And the ability for adult protective to get access to the actual document and to get access to the records and the accounting is critical for us to keep our clients safe. And sometimes we're going to have to bring these proceedings, and we might have to go to court multiple times, but ultimately I'm confident that we'll either have some jail time or we'll have accountings done to the satisfaction of the court.
The way they are supposed to be, for the good, as you say, of the clients that you're trying to protect. I mean, that's the bottom line.
Right. In the statute, the benefit of the statute says they are to keep a separate accounting. There's not to commingle their funds either. So they have a fiduciary role. This shouldn't be new. We're not ever surprised when family members are acting as powers of attorney under a power of attorney for their family, and they may not keep the best records. When they respond to us with the answer is that we're never going to provide you with anything, that raises a red flag. And in this particular one, it's a case where we've had multiple referrals, and it's not a relation, it's not a family member. It looks more like a scheme to us than anything else. So.
But that's a lot of what today is about, I think, being vigilant and being proactive in terms of keeping clients safe. I know Alan's going to talk about that quite a bit, and it seems that that's a lot of what your cases are about, or using interesting legal kind of arguments and different cases to keep folks safe.
That's exactly what our role is. And this is the legal side, too, and just using some of those tools that we do have is we always, when we're doing trainings for new workers, what we're doing, we're talking about we're not child protective for adults. Mm-hmm. We're a different animal. We have less authority and less power, but we need to take advantage of the laws that are there to assist us. A few more cases. Matter of Jewish home of Rochester. This was someone, a child brought parents to a nursing home and brought them from New Jersey, using a New Jersey power of attorney, put them in a nursing home in New York State, and then kind of ran away. The nursing home brought a special proceeding against this person to account and to make them see what's going on with the treatment of their parents. And the child actually contested and said they lacked standing to bring this. To bring the action. Bring the action. And the court actually ruled in favor of the nursing home and found that, yes, they do have standing. They're a third party required to accept the power of attorney. So based on that, they do have the authority to bring this action. And he also wanted to challenge the power of attorney, saying it's a New Jersey power of attorney, it's not a New York power of attorney. But the court looked at it and said, under full faith and credit, we're going to interpret that, and we have to look at this. So that case moved forward. They didn't rule that he had done anything appropriately, but the case got to move forward. Next couple, and we'll go quick, there's a couple more cases. The McGregor case, talking about special proceedings being able to be commenced by spouse or child or principal. In this particular case, it was a brother that wanted to enforce the power of attorney or challenge a power of attorney. And what the court found is that he did not have standing. Brother does not fall under the list, so he was not allowed to proceed. And the final case, and I do want to, this one is Suffolk County, and Dunlop versus Suffolk County. This, when I do trainings for new workers, we talk about liability of workers, and this is one of their biggest concerns, is what's going to happen when I'm out in the field, I'm a new worker, am I going to be at risk of a lawsuit? And in this particular case, the county made a determination that the gentleman was eligible for adult protective services, and were assisting the person in what they really were doing, and they were giving them resource referrals. Mm-hmm. One of our roles as adult protective is we're supposed to get the person safe, and one that we're a conduit for services, make referral to appropriate services. In this particular case, they did that. They tried that and made referrals for this person who was 600 pounds. So he was morbidly obese and had some other health issues. Mm-hmm. But what the county did was, because he didn't accept the referrals, and based on their investigation, they also found that he was ambulatory. He drove his own car. He went to his own medical appointments, and he did his own shopping. He was able to do that. And he had a large support system of friends and family. So they terminated his case because he no longer met the criteria, and they had offered him services, and he didn't want to follow through with them. And what happened in the case was, gentleman passed away at home. Okay. And the family member sued Suffolk County,
saying that service had not been provided.
That they should have either kept the case open or they should have forced services, that it was their fault. And the county moved for a motion to dismiss or summary judgment. And the trial court denied that motion for summary judgment, saying that there was a triable issue of fact as to whether they discharged their duties appropriately. And this did go up on appeal to the Second Department, and the Second Department ruled that the family failed to raise a tribal issue of fact as to whether the decedent's death was a result of willful acts or gross negligence of the caseworker, gross negligence of the caseworkers. So in the end, the county did win.
Yeah.
They did what they were supposed to. In this particular case, the immunity did kick in. They hadn't acted outside the scope of their duties. They weren't grossly negligent, or they hadn't willfully done something to this gentleman.
It's just really fascinating to hear this perspective from you, Morgan, as someone who actually does practice these cases. And I really can't thank you enough for being here with us and for all this great info you've just shared with us.
I know it's a lot and it was quick, but I really appreciate the opportunity to be here too.
Morgan really has shared a ton of great information with us. He is going to leave our panel for a bit, but he will return later to answer some questions and feedback from everyone. Right now, though, we're going to take a quick break. When we come back, we'll be joined by Alan Lawwitz, who's going to share updates on current agency issues, including some information on new ways to address and prevent financial exploitation, as well as available APS law-related training resources. Please continue to send your questions in, and we will see you back here in just a few minutes. Welcome back. We are now joined by Mr. Alan Lawwitz. Alan is the director of the Office of Children and Family Services, Bureau of Adult Services. He's had a long career focused on the safety and well-being of older New Yorkers and vulnerable adults. He's been really instrumental in improving communication with local districts. Today's training is a continuation of these efforts. Welcome, Alan. Thank you so much for being here. I just realized that I've lost my question cards, but
well, that's okay.
That's all right.
Hello, everybody.
We've got a lot of interesting things to talk about, and the first topic that we're going to touch on is the new Financial Industry Regulatory Authority, Finra. They've come out with a Rule 261 that kind of relates to financial exploitation. I'm hoping you can tell us a little bit about that.
Sure. This is a rule that went into effect very recently, February 5th. It permits Finra members to place temporary holds on disbursement of funds or securities from accounts of specified adult customers when there's a reasonable belief of financial exploitation of these customers.
Now, it's a great acronym, FINRA. I just spit that out pretty quick. But what can you tell us about this? Because not everyone is aware of this authority. What is the Financial Industry Regulatory Authority?
Well, FINRA is, as you can see, this was from their website. They're a not-for-profit corporation authorized by Congress to protect American investors by making sure that the broker-dealer industry operates faithfully and honestly. These are the people who sell securities. Okay. You know, like Morgan Stanley, Merrill Lynch, Charles Schwab.
Well, let's go there for a minute. So who can belong to FINRA then?
Okay, and I think with the next slide, we have eligible members are the registered brokers, dealers, municipal securities brokers or dealers authorized to transact any branch of the investment banking or securities business in the United States. Can be admitted to FINRA membership.
So you used a term before, specified adults. This applies to specified adults. I love these terms. How does FINRA define specified adult?
Right. It's defined in that rule, FINRA Rule 2165, as a natural person, age 65 or older, or a natural person, age 18 or older, who the member of FINRA reasonably believes has a mental or physical impairment that renders the individual unable to protect his or her own interests. Sound familiar?
Yes. Sounds very familiar. What do they define specifically as financial exploitation? Because, again, devil can be in the details here.
Right. They have the definition here, and the definition is fairly similar to the APS definition of financial exploitation found in social services law. Is the wrongful or unauthorized taking, withholding, appropriation, or use of a specified adult's funds or securities, or any act or omission by a person, including through the use of a power of attorney, guardianship, or any other authority to obtain control through deception, intimidation, or undue influence over the specified person's money, assets, or property, or actions to convert the specified adult's money, assets, or property.
So, Alan, what kind of actions then can a FINRA member actually take if they believe that a client is either at risk of or currently experiencing financial exploitation?
The rule authorizes a broker-dealer that reasonably believes that financial exploitation has occurred, is occurring, has been attempted, or will be attempted to place a temporary hold on the disbursement of funds or securities from the account of a specified adult customer. And I think we see on the next slide that once the brokerage firm places a temporary hold, the rule requires the firm to immediately initiate an internal review of the facts and circumstances leading to the belief that financial exploitation is a concern. The brokerage firm must also, no later than 2 days after placing the hold, the firm must provide notification of the hold to certain persons, to the customer, to all parties authorized to transact business on the account, and to the customer's trusted contact person. There's that term, trusted contact person. What's a trusted, or who's a trusted contact person? This rule also requires brokerage firms to make reasonable efforts to obtain the name and contact information of a trusted contact person for a customer's account. The trusted contact information, if the customer agrees to provide it, the trusted contact information is supposed to be a resource for the firm to help protect the customer's assets. However, and this is, I think, on the next slide, that the brokerage firm does not have to notify a party who is authorized to transact business on the account, does not have to notify the trusted contact person if such person is unavailable, or significantly, if the firm reasonably believes that such person has engaged or will engage in financial exploitation of the specified adult.
So the firm can kind of try to make sure that that person isn't also
protected, right, if they're seeing the financial exploitation.
So we're talking about a temporary hold, Alan, here.
That's right.
How long does that temporary hold last?
Okay, the rule says that the temporary hold expires no later than the 15th business day after the date that the member first placed the hold, unless it's terminated or extended by an order of a state regulator or agency or court of competent jurisdiction. So the hold can extend beyond the 15 business days if either the brokerage firms, remember they have to do an internal review, if they do an internal review and the internal review supports that there is financial exploitation, the brokerage firm can extend the hold for another 10 business days, for a total of 25 business days, or it can be extended by an order of a state regulator or agency or court. This language also says, of course, that the 15-day business hold, or if they're adding the additional 10 days, that hold can be terminated by an order of a court or by an order of a state regulator or agency. So we will come back to this in a couple slides. We'll come back to this language about state regulator or agency and how this might apply to APS.
Okay. But before we do that, does this new rule we're talking about, 2165, are there protections for FINRA members with all of this, for holds and all this kind of stuff?
Yes, there are protections in that the rule provides the brokerage firms with a so-called safe harbor when its members act in accordance with the rule. I asked counsel to FINRA, what does the safe harbor mean? And I was advised that this means that if the members comply with the rule, FINRA will not come after them to seek a penalty or a sanction for failure to provide the account funds to the customers. I also asked counsel for FINRA whether the rule provides for some sort of civil or criminal immunity in a lawsuit, and I was told that the safe harbor is limited to FINRA's enforcement action. So it doesn't necessarily mean immunity if a lawsuit is brought.
On an individual. Yeah. So what kind of then other requirements are there for members of FINRA? I mean, are there additional responsibilities?
Yeah. The FINRA requires that the members establish and maintain written supervisory materials to comply with the rules, including procedures on identification, escalating, and reporting of matters related to financial exploitation. They have to, each firm has to identify internally, the titles of persons who are authorized to place a hold, terminate a hold, or extend a hold. The members have to develop and document training policies, training programs designed to ensure compliance with the rule.
So when we look at our APS world, Alan, what does this all mean for APS?
Well, I think there are a few implications for APS here. The rule itself is a recognition that financial exploitation of vulnerable adults is seen as more pervasive than ever. It's a recognition that brokerage firms are seeing more and more financial exploitation, as APS is, and that the industry and its regulator sees a need for additional ways to address the issue. So as a result of Finra Rule 2165, APS may wind up getting additional referrals from securities brokers of suspected financial exploitation. Brokers who place holds on accounts under this rule may well be contacting APS. In addition, since, as we just said, the rule requires that brokerage firms develop training policies and programs designed to ensure compliance with the rule, and since the rule requires its members to establish written supervisory procedures, including rules on identification and escalation and reporting of matters related to financial exploitation, it's likely that local APS, OCFS, both, may receive requests for education of securities professionals, on the role of APS and how to make reports and what an APS investigation, may consist of. So if we go to the next slide, so it's important to note that this, as I mentioned before, this rule contemplates that APS agencies may request extensions of temporary holds. Remember a few slides back, we saw that the rule says that the usual 15-day business hold may be terminated or extended by an order of a state regulator or agency or court of competent jurisdiction. So I went and looked at FINRA's frequently asked questions on this rule, and that's in the handout. But it discusses extensions of temporary holds, and the FINRA expressly includes APS as an agency that may ask a member to extend the temporary hold to give APS additional time to investigate the case. And I think you'll find this part of the FAQs on the top of page 53 in today's handout.
In fact, yeah.
And so I contacted counsel for FINRA to ask about the wording of this part of the rule and the language that's used in the FAQ, the frequently asked question. The FAQ refers to, quote, a state agency such as Adult Protective Services, securities regulator, or other state agency or regulator, close quote, requesting an extension. I said, in New York, as in many other states, APS is administered not by a state agency, but by a local county or city agency. FINRA counsel confirmed to me that despite the use of that quoted language about a state agency, FINRA feels that a local APS agency is authorized to request an extension of the hold. So for how long can APS or other agency request an extension? No outer limit is provided in the rule or the FAQ, except to say that the agency would be requesting the extension, quote, so that it has more time to investigate the matter, end quote. And I also asked FINRA counsel, is there a particular form that APS or other agencies must use to request an extension of the temporary hold pending investigation? And he said no, there is no particular form. And the FAQs say that the agency doesn't need to issue a formal order of any kind to make the request for an extension. So this is new authority, and it's going to be interesting to see how this develops. I mean, we've reached out to FINRA. We've reached out to SEC, the Securities Exchange Commission, which also regulates securities, and let them know that OCFS and local APS will be happy to respond to their questions and help them any way that we can.
Well, thank you for passing along the research and the communication with Finra's counsel. And again, as Alan mentioned, that frequently asked question for Finra is on page, I believe it starts on 52, and do find it in your handouts. A lot of great information. Staying on the topic of financial exploitation, Alan, let's shift focus right now to something very interesting, convenience accounts. Many elderly and vulnerable adults choose to open joint bank accounts with family or friends, but convenience accounts can be a more secure option. What are convenience accounts, Alan? Because I had never heard of them before this.
A convenience account allows the creation of an account in the name of a depositor. Let's call her Sarah Jones. And of another person. Let's call her Rachel Jones, the daughter of Sarah, which is also a local nursing home, daughters of Sarah. But all funds that are deposited in the account, whether they're deposited by the mother or the daughter, are for the mother's benefit only. Both Sarah and Rachel can deposit funds in the account, and both can take money out to pay for the mother's bills, but it's done only for the benefit of the depositor, Sarah. So banking law section 678 provides for convenience accounts, and this section is included in the handouts. And when the depositor dies, the other person on the account, the daughter, has no right of survivorship. And so that's a key characteristic of a convenience account. The money remaining in the account is considered part of the depositors, the mother, Sarah's estate.
So talk us through then, Alan, how we could see a client use one of these accounts. I mean, what would this be like? What would this be to an APS worker?
Yeah, and this is, okay, this like kind of restates what I said before. They allow for an elderly or infirm person, the depositor, to set up the account to allow a son, a daughter, or a friend, the helper, to be on the account for the purpose of helping to pay bills and expenses out of the account for the benefit of the elderly or infirm person without gifting the money to the helper.
And that's what I want to get at. Can you talk to us about why this can be a better choice for clients sometimes?
Well, we want everybody to know about the possible availability of a convenience account as an alternative to a joint account. Joint accounts are often used in a situation where the vulnerable adult believes that the other person on the account is there as a helper. But joint accounts are so much more than that. In a joint account, as you see on the slide, both persons on the account share ownership of the funds. In a joint account, a co-owner's debts can create problems. Creditors can seek payment from the joint account even if the debt itself belongs to only one of the owners. And in a joint account, if one account owner dies, the other account owner is presumed to have a right of survivorship. And that's set out in banking law section 675. So this generally means that the co-owner gets the proceeds after the other owner dies. So we frequently hear of cases in which an APS client has allowed another person to become a joint account owner. And sometimes that other person proceeds to take out all or nearly all of the funds, of the client's funds, from the account. And in such a case, there's not much that APS or law enforcement is going to be able to do to prevent the other person from draining the joint account, because they have an equal right to withdraw any or all of the funds in the account. If the APS client dies, the other person has a right to the funds remaining in the joint account, because there's a right of survivorship in a joint account. The only possible way to contest this would be in the rare case in which there was evidence that could be shared with the police or the DA or the bank that at the time the joint account was created, the client clearly lacked capacity to understand that their money was going into a joint account, and that you could also prove that the alleged perpetrator joint account owner clearly knew that the client lacked capacity and that there was fraud or coercion that could be shown. But in most cases, it takes a lot to prove that. In most cases, you won't have that.
So, Alan, how do you make sure then that you're actually setting up a convenience account as opposed to a joint account or some other kind of account?
It's got to have some magic language. You want to make sure that it's stated in the account that it is, quote, for convenience only. Use those words. and is intended to safeguard the funds of the named depositor. You want to make sure that the account states that the helper has no ownership or survivorship rights to the funds. And you want to make sure that there's documentation that the funds in the account can only be used for the benefit of the named depositor. So recently, I went to the primary financial institution that I use, which is SEFCU, State Employees Federal Credit Union, to do a reality check. And I asked whether they offer a convenience account. They do. And I obtained their convenience-only account disclosure forms. And this form contains the provisions that were mentioned in this slide. You know, it states that the account is for convenience only. It states that the funds are the property of the owner individually, and it states that upon the death of the named owner, the credit union will make payment to the executor or the administrator of the account and not to the other named person on the account.
Those are great rules, and I think it's great that SEFCU has that.
I was happy to see that, you know, my primary financial institution does have that.
So an interesting question I just want to mention before I ask this, there is information starting on page 56 of the handouts regarding this on sections 675 and 678 in terms of banking law. I think if folks are kind of looking for some of that specific info, but you raised an interesting question. Do all financial institutions offer convenience accounts as an option?
Probably not.
Okay.
Because under current law, financial institutions are not required to offer convenience accounts. There was a legislative proposal last year that would have added this as a requirement, but it was not enacted. So I suggest that you ask banks and credit unions in your community whether they offer accounts for convenience only, so you'll know whether this is an option to be able to suggest to clients, families, and other professionals that you work with as a vehicle to offer more control and protections to clients over their funds.
Now, as many folks in the APS world know, joint accounts are not subject to protections typically afforded to principals under a power of attorney. What about convenience accounts?
That's true. If you're going to have someone act as your helper to assist you in handling your financial affairs, then entering into a power of attorney agreement and naming that person as your agent does provide additional protections. And some of those protections are ones that we've talked about before. You know, under a power of attorney, an agent has a fiduciary duty. There's a caution to the agent that's listed there. There are requirements that agents have for documentation of transactions. There's a warning to the principal that, you know, the agent can really do a lot with your money without you knowing it. There's a power of attorney has the ability to name a monitor, another person who can oversee how the agent is using the funds. For power of attorney, there's ability of APS or the monitor and others to issue the 15-day letter to require accountings and to seek special proceedings. There's a listing, and a power of attorney has a specific listing of powers that are granted to the agents. So powers of attorney provide a lot more protection than a convenience account would. But we also know, on the other hand, that most people don't execute powers of attorney. They're more likely to just add someone to their account to help them out. So my strong suggestion here is to explore the availability of convenience accounts as an alternative to entering into a joint account in such cases.
That's a great suggestion. Thank you for bringing that up. Let's move on to another agenda item that I know you're anxious to talk about, the Gatekeepers Toolkit. Last year, the Bureau of Adult Services partnered with the New York State Office for the Aging to develop this training for caregivers and service providers, or gatekeepers, who have frequent contact with older adults. So a toolkit has been developed, Alan. What can you tell us about this toolkit? It's supposed to also help fulfill some legal requirements for APS for community outreach. Can you talk about those?
Sure. I'll start briefly with the legal requirements. Our regulations require that on an ongoing basis, APS educate the public, service providers, advocacy groups, and other appropriate agencies about the scope of APS and how to obtain APS services. This is found at 18 NYCRR section 457.7. There are additional regulations that say that APS must provide continuing community education and networking activities regarding APS procedures for provision of services in involuntary cases. Over the years, OCFS has developed and distributed a variety of different types of materials to assist local APS in meeting its legal requirement to conduct such outreach and education. And some of you may recall that in the 2016 Legal Aspects of APS webcast, Paula Vielkind and I presented on this topic. And I've included in the handout, I think on page 105, the listing of some of the available tools that we've had to date for outreach, and all of these can be obtained either from the OCFS website or by contacting your Bureau of Adult Services representative. The new Gatekeeper Toolkit is another significant resource that's available for local APS to use for help in community education and outreach.
And you know, it's interesting, we briefly mentioned that this was done, I think, as a collaboration with State Office for the Aging. You know, can you give us some more information on how things were sort of developed? How did this all come about?
Sure. Well, last year we talked about the recently enacted update of the MOU between
Yes.
Office for the Aging and OCFS, and the model agreement between the local APS and local Office for the Aging. So this is an initiative that was jointly developed by OCFS and Office for the Aging, and my vision of it was this was a community education and outreach task that local APS could do in tandem with local Office for the Aging to share community resources. OCFS Acting Commissioner Sheila Poole introduced this Gatekeepers Toolkit at our most recent AATI, and copies of the toolkit were distributed at AATI. Plus, our office sent electronic copies of the toolkit out to APS supervisors and all units this past November. And again, our hope is that local APS will partner with local Office for the Aging to present this. Of course, APS could also present this on their own if local aging does not want to participate.
So, Alan, when we think about this toolkit, and we'll talk about the pieces of it in just a minute, but what are your goals? What do you hope to accomplish by making this available?
The Gatekeepers training is intended to help educate community groups to recognize warning signs of possible abuse, neglect, or financial exploitation, to help educate community groups to take steps to prevent abuse, to be able to report suspected abuse, and it's also a goal to share information about available community resources.
Let's just talk for a minute, though, about who the folks in this group are. It was right in the title, the gatekeepers.
Yeah.
Who are these gatekeepers that should be participating in this training?
The term gatekeeper is intended to include those persons and those community organizations who have frequent contact with older persons. We're hoping that such persons and their organizations can help identify vulnerable adults in need of assistance, either from APS, local Office for the Aging, or other community resources. And we're hoping that these gatekeepers can open the gates to links and services and supports to help vulnerable persons maintain their independence and, to the extent possible, be able to remain in the community. Yeah. We're hoping that the gatekeepers will work with APS, Office for the Aging, and other local providers to help prevent or reduce isolation of older vulnerable adults. So possible gatekeepers who can benefit from the training, you can see the list that we have on the slide. These are all people who come into frequent contact with older persons, from the home-delivered meal staff to clergy and faith-based volunteers and postal services, nurses, companion caregivers, senior services, staff, neighborhood associations, and there are others.
So let's talk about what's included in the toolkit. There are three main parts to it. Can you just kind of talk about what is in here?
We've got a draft flyer to help publicize the local presentations that can be adapted, locally. We have a PowerPoint presentation for the Gatekeeper program. Again, that can be adapted. There's a lot of slides there. It can be reduced to meet local needs. There's also a guide to planning your presentation.
In fact, I just want to mention, too, that starting on page 60, I think, of the handouts, we can find that PowerPoint, the flyer, as well as that guide, because that's important. And I do want to talk about that. Different districts, though, it occurs to me, Alan, do have different needs. Talk to us about things that different districts can do to respond to their communities. Can this be expanded? Can this be changed? Can it be customized?
Yes, yeah, and we hope that that will happen. So we are encouraging local APS, local aging, to modify their materials as they feel are appropriate to meet their local needs. We hope that they'll add their own local brochures, posters, other materials to help inform participants about local community resources. We do hope you will use this and adapt it as meets your needs.
Can you just spend a few minutes kind of walking us through, I know that we've got some on screen, can you take a look at with us this toolkit and how folks can use it too?
Sure. Well, just I'll show you a few slides and kind of give you a flavor. You can see learning objectives on the next page. What are we trying to do? We want to identify characteristics of older vulnerable adults. We want to be able to describe and recognize older adults at risk, identify community resources, know how to take steps to prevent suspected abuse, know how to report suspected abuse. Go on to the next slide. We include a number of red flags that may indicate abuse and neglect. Here's some that relate to indicators of physical abuse. Or sexual abuse or active neglect. So we want to familiarize the gatekeepers with the red flags. We can move on to the next one. And what is APS? What does it do and what does it not do? What are the criteria? So this lists the APS criteria, eligibility criteria. You can go on to the next, please. And then APS, and it's important for people to know that APS handles self-neglect cases as well as what we call the perpetrator-related cases. And a lot of the people who may be isolated are going to be those self-neglect. And the vast majority of APS cases are self-neglect. So it's really important that people in the community not think of APS only for where there's suspected physical or sexual or emotional abuse,
sure,
or a perpetrator. So we talk about that. We can go on. How to contact APS. As we put the county or city Department of Social Services number. We also add the Adult Services helpline, the statewide helpline number. Want people to know about that as well.
I like that you have a listing of services as well. I think that's really handy. It tells these frontline folks who may not be aware of your services right up front what the county might be able to help them out with.
Right. Right, and we can move on to a couple other slides. Here's some of the services that APS can provide. We can move on, let them know of the range. And here's some of the services that are provided by the Aging Network, that you can seek help from the local office for the aging. And we have a couple slides on that. Here's one, and here's another one. A lengthy list, of services provided at the Aging Network. Okay, and we can move on as well. So, we're asking the community groups, the gatekeepers, to be additional eyes and ears for APS and Office for the Aging. Help us protect vulnerable older adults. Be alert. Help us identify vulnerable older adults. Share information about available community services, and if you suspect abuse and neglect, call APS and take steps to stay in contact with the older adult. And we have some information and some other slides about what people can do to stay in touch with older adults and try to prevent or reduce isolation.
I really like the planning guide that is included in this training. In fact, I just want to mention it's on, I think, page 101 of the handouts if folks do want to look specifically at that planning guide. That's a terrific asset. Tell us how this can be used, Alan.
Well, and it's envisioned not only for planning a gatekeeper training, but any other type of training that you're going to do about elder abuse or adult abuse. There's certain things that we hope will assist people who are planning to provide elder abuse or adult abuse related trainings to community groups. It'll help you consider some important questions, like who's the target audience? Is it professionals? Is it members of the public? Is it a mix? What's the length of the program? Are you going to use all the slides that we have provided or only a portion? Will you add some interactive activities? Will you add a video? How many presenters will you have? How much time for each? How are you going to handle questions and comments? Are you going to, and we hope you will, you'll supplement the content with some examples of local cases. This will help gain interest and works well to illustrate some important points. How are you going to set up the presentation area? And we also are suggesting things like at or near the beginning of the presentation, you invite the participants to talk about how they come into contact with older adults who may be at risk. Have them talk about what are the circumstances? How does it make them feel? You know, what do they hope to get out of this session? You know, so we also include a number of additional discussion topics that relate to, that often will come up when you're talking to community groups about adult abuse, elder abuse. There's much more. So we do hope that people will use this planning guide, and please let us know if it's considered a helpful resource.
And just real quick, Alan, I know we have a slide on screen. We'll get that up about how folks can get a copy of the Gatekeepers Toolkit. Can you mention how folks can reach out and find one of those?
Yes, you can contact our Bureau of Adult Services, contact your representative, to get it. We'll be happy to send it out to you. And we hope you will use it, and we hope that you will tell us that you have done that, so we can help publicize that fact. And we'd love to take pictures of you presenting a Gatekeepers presentation and put it in our Adult Services newsletter.
Speaking of kind of resources for folks, Alan, the toolkit is just one of many really training resources available through OCFS. Let's take just a few minutes to review those resources that do focus on legal issues in adult protective services. Before we get into the specifics of what we're talking about and what kinds of things are being offered, Alan, where can we find the trainings and presentations that you're going to be talking about right now?
All of the resources that I'm talking about, we have them on DVD.
Okay.
For many of them, they're also posted on the Human Services Learning Center, HSLC. I'm looking at the screen so I say it right. So we'll be able to differentiate that. And if you're not sure about whether a resource that is listed, you know, whether it's on HSLC or not, contact your Bureau of Adult Services rep.
Okay.
And we'll make sure that you get it.
So
we'll get access to it. You know, because the thing is, if you know it's on HSLC, then I think my understanding is you contact your local staff development coordinator, and they help you register for the HSLC offering.
And then you can have access to those courses, absolutely.
Right.
So you do have 2 new trainings that were just uploaded to HSLC. Can you give us some information on those?
Oh, sure. There's 2 good ones that were at the most recent AATI. They were recorded there. The first one, Advanced Directives and Powers of Attorney. Julianne Calicero, who was a private attorney, gave an excellent discussion about advanced directives. I highly recommend it. So that's one. There was another one on elder-adult dialogue and mediation, done by an attorney, Sarah Rogers-Ties of the Executive Director of Mediation Matters.
Yeah. I think Alice Rudnick from Court Administration did that as well.
That's right. She was also. So that's really good, and it's a good resource because we know, and given how many APS cases relate to family disputes and other situations in which mediation can be very helpful. And mediation is not necessarily, within the APS toolkit, but this session will kind of bring to your attention where are the local resources for mediation and how they can be helpful in elder abuse situations.
It was a great presentation, free and low-cost resources. Talk about some other trainings that are currently available, because I know there are quite a few.
Yeah.
We've done a few.
You'll see on the handout, I think it's beginning at page 107, as a list of law-related APS trainings. There's an overview of forensic accounting best practices, That's on HSLC. There's a presentation called Anatomy of an Article 81 Guardianship Proceeding that discusses the differing roles and responsibilities of the petitioning attorney for APS, the court-appointed evaluator, the counsel for the alleged incapacitated person. Both Morgan and I participated in that session. Also, Rosemary Bailey of Albany Law School and Sheila Shea, attorney for MHLS. So that's there. There's also a training of financial professionals, how to recognize, prevent, and report financial exploitation. This is a recorded version of one of a series of these trainings that we've been doing across the state, co-sponsored by OCFS and the New York State Department of Financial Services, and we include local APS and DA's office and nonprofit providers. And Morgan participated in the one that was held in Syracuse in 2016. So this is accessible via the OCFS Internet APS website. You can see the links. There's an 18-minute highlights reel, as well as the full 2-hour version. And and we have the PowerPoints available from our bureau as well. I think the PowerPoint is on you can see it on the screen, but if you want it in hard copy, you can contact our bureau.
And I would point out that past versions of this webcast, our greatest hits, are also available, Alan.
That's right. That's right. And as well, you'll see there's several others that are also mentioned. We have one on involuntary mental health interventions that was presented by 2 attorneys, one OMH attorney and an MHLS attorney. There's a recorded training called Case Management and Legal Liabilities for the APS worker that Deb Sachs and I did a few years ago. And there's also a 2-part training on Article 81 Guardianship done by Deb Sachs and myself a few years ago. That's also available. And you're right, we have recorded the legal aspects. And often we get a question about a topic that we've presented on before. And so we wanted to make sure that APS staff and agency attorneys have a listing of topics that may come up, that may be helpful to view a short presentation on a particular topic. And say, okay, and this slide shows, for example, what we did topics in 2017 and 2016. But in the handouts, you'll see we're going back several earlier years. And say you wanted to see a short presentation on APS orders to gain access, go to the 2015 webcast and you can see that. Or you wanted to see a presentation on Family Healthcare Decisions Act and go to 2011 webcast and view it. So we just wanted to make sure that that was available.
Well, thank you for sharing. It's a great resource for folks. Now, though, we are going to move on to our final topic for the day. Alan's going to share some information with us on new 2018 hospital diagnosis/billing codes for adult maltreatment and sexual abuse. What are these codes, Alan, and what can you tell us about them? I actually never heard of these before.
Well, one folks to know about this, as the slide says, the International Classification of Disease, or ICD, it's a set of diagnostic codes that are written by the World Health Organization and then adopted by countries around the world. The ICD-10-CM is the current modification of these codes used in the U.S. So we set out on the slide, this is the billable and specific code that can be used to indicate a diagnosis for unspecified adult maltreatment confirmed initial encounter. So we're thinking this information may be useful for APS and agency counsel to have when working with hospitals and medical professionals on behalf of APS clients for whom there may not be another billable diagnosis. So this may also help encourage treatment and retention of APS clients in hospital settings. And under the code, there's also listed so-called appropriate synonyms, and you can kind of see basically the different versions of adult abuse and adult maltreatment or elder abuse. And similarly, there's a billable diagnostic code for adult sexual abuse that's listed on another slide, and you can see those so-called appropriate synonyms as well. I spoke recently with Art Mason of Lifespan, and he related to me in his experience, some hospital social workers and nurses will tell you when he or his staff say, hey, you know, there's a billing code for this, and they say, no, that doesn't exist. But then, and they would initially refuse to admit a client. However, after being shown the billing code and they're looking it up in their computer, they would have some success and they would admit a victim of elder abuse. I should mention there was a earlier version of these codes was referenced way back when, state DSS guidance going back as far as 1991. Wow. 91 INF 53. I'm sure each of you have that right on your desk. But what districts were alerted to the availability of these codes, and which was available to hospitals to cover costs of hospital admission, testing, and treatment of victims of abuse and maltreatment. So that INF encouraged APS to explore this option with hospitals whenever the admission of APS clients who were victims of abuse and neglect was contemplated, and there was some pushback from the hospitals saying we don't have a way to pay for this. I also reached out, interestingly enough, to this Dr. Tony Rosen of Weill Cornell Medical Center, and he's with New York Presbyterian Hospital. And I asked him about the diagnostic code for adult maltreatment, and he responded that the use of these ICD diagnoses differs between providers in different health systems, particularly for, and I'm quoting him, particularly for a socio-medical phenomenon such as elder abuse. In case of injuries, providers may choose to code the type of injury. Say, you know, if there's an ulnar fracture, code that. There's a billable specific code for ulnar fracture rather than looking for a code for the cause or mechanism of injury. Because in some cases where a provider or even a provider strongly suspects abuse, they may prefer to avoid labeling an injury as abusive without an in-depth investigation that they've done. So if they have a more specific, you know, billing code for a broken bone or something else, they'll often cite that. But I also raised with Dr. Rosen whether he thought the availability of these codes might be the basis for encouraging hospitals or other healthcare settings to do a social or safety admissions of APS clients who were victims of abuse and maltreatment. He said he thought, you know, that there was some interesting potential to use this if this is brought to the attention of hospitals, and there's a mechanism to use that. So I want to plant a seed here, suggesting that some of you may want to try to have discussions with local hospitals or other medical providers to see if they'll accept these codes to try to pay not only for treatment of abused victims, but also to pay for social admission.
Sure, absolutely.
Worth a try. Worth a try.
That's a great suggestion.
And that's it on the ICD codes. And I know I've had a lot of information to convey this year, so hopefully it hasn't been too dry and too boring.
No, Alan,
but I think it's important information.
Everyone genuinely appreciates what you pass along. The direct conversations you've had with folks are very valuable knowledge to pass along. He shared some great agency updates with us as well. Right now, though, we're going to take one final break because when we come back, Morgan Thurston is going to rejoin us to answer audience feedback and questions. We will see you in just a few minutes. Welcome back, everyone. Let's now take some time we have left to answer the questions we've got in. Thanks for being back with us. Morgan, thank you. First question for everyone. If a securities investment broker does make a referral to APS concerning suspected financial exploitation involving the misuse of a vulnerable adult's investment account, can APS request information from the firm, the investment firm, about that investment account using the standard form we already used to request bank account info? Is it the same form? Is it a whole different thing if it's an investment?
Let me respond to that, because I did contact the Finra Council, I contacted the Consumer Federal Protection Bureau, and I actually contacted the Security Exchange Commission because they regulate securities. And they confirmed that, yes, you know, we've talked before about the bank privacy laws and the federal privacy law, the Graham-Leach-Bliley Act, and they confirmed that, yes, that interagency guidance that they put out in 2013, SEC was a signatory to that, and yes, the Graham-Leach-Bliley exemptions do pertain to securities. So yes, and I told them what we intended to do. We intended to send out that standard letter to securities firms, and I think we would just need to modify it and put the other to request the security account information. I think in these cases we would also want to see who is authorized to transact business. So APS can see, what's happened to those security accounts and who had access to those security accounts.
I believe the standard letter was included as a handout, maybe, because I know you covered Graham Leach Bliley,
right.
I believe, in a webcast a few years ago. So as
yes.
you said, keep in mind those trainings are online.
Right,
Folks can go
and
back
it's listed
and look at those.
on one of those in the PowerPoint presentation that we just did.
It's handy how we do that, isn't it? Yeah. Moving on, in a guardianship proceeding, what if the attorney for the AIP, the alleged incapacitated person, what if their attorney objects to the medical testimony by the AIP's physician, and then the court prevents the physician from testifying about the diagnosis? How do I approve guardianship? And I get this. This has been covered.
Yeah, it's an interesting point. When I'm proving a guardianship proceeding, what the statute says is that a court can't require medical proof to prove a guardianship, but HIPAA doesn't go out the window, and attorneys will object to a treating physician giving a diagnosis. What the guardianship proceeding is about is functional capacities.
Okay.
So I want to prove what can this person do for their activities of daily living. I really don't care about a diagnosis. I want to be able to show what the impact of that diagnosis has on their activities of daily living. What I can generally do, as far as medical testimony is bring in a non-treating, like a charge nurse.
Okay.
Someone that is familiar with the client, familiar with their chart, but not actively providing care for that person because it's not a medical testimony reviewing the chart. And the same for social workers, they can typically give that testimony as well.
Right. And you mentioned HIPAA. It's also they'll cite an objection under the physician, the state physician client, physician patient.
And when I started 15 years ago with the county on these cases, that judge that all our guardianships were in front would not allow any medical in whatsoever. So I had to change my practice based on the court I was dealing with. But I think it makes sense, though, realistically, is that we're proving what is the person's functional capacities. A diagnosis doesn't necessarily mean that.
Julianne Kelleriso did cover that in one of the AATI trainings, Advanced Directives, that was recently posted to HSLC. I do just want to mention that because obviously it's a question that folks have.
And it comes up because we've gotten that question periodically and recently.
Wow. Morgan, this person is mentioning, okay, a change in the social services law. You talked about the responsibility of an adult home enriched housing program. That is what I remember you talking about. Or a residence for adults to report deaths, enriched housing program, or a residence for adults to report deaths to the Department of Health, as well as to report them to law enforcement in appropriate cases, as well as the Justice Center. So what are the requirements for death reporting for family-type homes for adults? Can you go over it again?
Well, I'll pick that one up. Family-type homes are also subject to both regulations that require them to contact the local district, next of kin, when there is a death. But their family-type homes are also covered by the Justice Center. Okay. And they are subject to the regulations of the Justice Center, and the operators are required to immediately report the death, make a phone call, within 24 hours after the death, and then they have to follow up with a Justice Center form, I think, within 5 days of the death. So the family-type home for adults operators are also required to report
They are
resident deaths, any resident deaths, not just suspicious deaths.
But any death whatsoever.
Deaths, yes, and that's required by the Justice Center, because the regs, talked about particularly a suspicious death, but the Justice Center has now said we want every death.
Well, that's an important note to make.
They even have a death reporting line.
Wow. Okay, but that's good to know. Any death, not just suspicious ones.
That's true.
So Morgan, actually, wait a minute. I have one more question. I heard there was a new law passed involving development of materials on elder abuse for the medical community. I lied. What does that involve, and what is the status? I do have one question after that. So new laws about involvement of development of materials for elder abuse.
Well, there is. It was effective last year, June, I believe, of 2017, and it actually requires Department of Health, NYSOFA, New York State Office of Aging, and OCFS to develop a toolkit essentially for coming up with, for healthcare providers to identify suspected self-neglect, abuse, and maltreatment of people over 60. So I guess the question I'll swing to Alan and say what progress has been made in developing these tools with DOH and.
We are awaiting, and I've heard recently from the Office for the Aging that they'll be contacting us because they're under that law. They were the lead agencies that they'll be contacting OCFS and DOH to meet with them. But this, I'm excited about this law because this will provide a good opportunity to talk about screening tools and different guidance, different questions that medical providers, not only physicians, but everyone in every range of healthcare, residential and community-based and doctor's office and everything else, and to do some more outreach and recognition.
Important communications and outreach with clients.
Yeah, so I'm hoping, that we'll have some further meetings and activity on that later this year.
Well, I know you will keep us updated if and when that does happen. That is all the time that the three of us have for today. If we didn't get to your question, we will follow up with you if you provided us a phone number or an email address. I very much would like to thank Morgan Thurston and Alan Lawitz for sharing their knowledge and expertise with us. Before we end today, I just want to remind you that that application for CLE credit for attending today's training is pending. So if you are interested in getting CLE credit, please fill out all the appropriate paperwork, sign the rosters provided, and complete the CLE credit request box. Again, that's the only way to verify your attendance. You can find that form on page 117 of your handouts. I'd also like to note that, like previous year's presentations of this webcast, today's program will be made available on HSLC later this spring. Please do keep an eye out for it if you'd like a refresher on the information presented today, or if any of your colleagues maybe were unable to attend. So please be aware that CLE credits are not available, though, for viewing this program on HSLC. Finally, we ask that you complete your participant reaction questionnaire before you leave today. Thank you again for your participation, as well as for all the hard work you do on behalf of vulnerable adults and the elderly of New York State. Have a great day, everybody.